uh, Wells Fargo versus Stephenson.
May it please the court, David Rosenberg on behalf of the appellant, Wells Fargo Bank. I'd like to reserve 5 minutes for rebuttal. If this court has no immediate questions or any issues you'd like me to address, I'll begin by summarizing our points and then going through the Appellee Stephenson's arguments. This is a case that was dismissed for lack of standing at the pleading stage. This was error. Our amended complaint stated a cause of action, which is all a motion to dismiss is designed to test.
All right, so you have a copy of the note, and you've got a blank endorsement, correct?
Correct, Your Honor.
All right. And so the issue here is a deviation between what's on the note and the documents, correct? Between Wells Fargo trustee for registered holders and trustee for certificate holders. That's the issue here, right?
That's the gist of it, except that, just to clarify, that's an issue on the assignments attached to the complaint. Not on the note and not on the endorsement. The endorsement's in blank from the original lender. That scrivener's error, if you want to call it that, appears only in the assignments. There's a 2012 assignment and then a corrective assignment. And that's where you have that scrivener's error.
Well, was there another trust for certificate holders and registered holders? Were there two separate entities?
It's unclear from the record. Our position is that it's irrelevant. That's under Ginsburg from the 4th DCA. Ginsburg says that to prove standing, a plaintiff is not required to identify or prove the trust on whose behalf the plaintiff acts, and that's based on...
At least at this stage, it's irrelevant for purposes of a motion to dismiss as opposed to an affirmative defense.
Correct, Your Honor, and that's under Wildflower. You also have Farello, both from this court. Wildflower says that ordinarily you cannot raise an affirmative defense like lack of standing at the pleading stage.
Appellee argues that the issue was not preserved for appeal. Would you like to respond to that?
Yes, Your Honor. Preliminarily, their preservation argument is flawed. It appears they may have overlooked our response to the motion to dismiss. That was filed on, let's see here, it was October 3rd, 2017, which is well before the January 8th, 2018 hearing. They never addressed that response to our motion to dismiss, so any arguments that they may make before this court at oral argument were not made in their briefs. That response to the motion to dismiss made the exact same arguments that we make here. It talked about Ginsburg. It talked about the four corners.
But a motions panel isn't binding upon the merits panel. So, I wouldn't take that as the law of the case. He can continue to raise it at oral argument, and you can continue to argue it because it's not a done deal.
Correct. Preservation, right. Of course, you could affirm even if there was nobody contesting
I'm just suggesting to you that the fact that a motions panel rules preliminarily doesn't bind the merits panel on the same issue.
Right. Agreed. So that aside, then the issues were preserved. This is standard motion practice. This is they file a motion, we file a response.
So what were the things in your response argued in the actual hearing before the trial court?
So we talk about that more fully in our brief, but again, at Ginsburg, that the identity of the trust is irrelevant to determination of whether or not we have standing. At this stage, you're only...
The question is, where was it raised at the trial court level?
In the response to the motion to dismiss, and then again on a motion for rehearing, just in case the trial court might have overlooked the response to the motion to dismiss, but the trial court didn't.
So it was raised in the written pleadings.
Correct.
But not necessarily in the actual hearing itself.
At the hearing itself, correct. At the hearing itself, the judge opened the hearing by saying, counsel, explain to me why this case should not be dismissed for lack of standing due to the assignments, and went off on, I mean, that's the opening of the
and
hearing.
That's never a good opening for the bank.
No, it's not. So our counsel attempted to avoid an appeal and tried to answer the trial court's questions to the best of his ability regarding the assignment, but the trial court made it clear that they understood exactly what was going on in this case. They'd reviewed everything. Their words, they reviewed the file, they reviewed the motions, they reviewed the circumstances, everything. They say that. The trial court says that. The trial court said it understood the issues and, quote, that's why I'm asking the questions. So it was clear from the record, clear to me reading over the record, that the trial court was very well versed. That's why I took charge of the hearing from the get-go and began asking, why shouldn't this case be dismissed for lack of standing? It was concerned about the assignments. It's just like we have here. If I were to want to talk about all these points that I have to make, but Your Honors decide to talk only about the assignments, I'd do my best to answer those questions. But I'm still going to stand by what I put in my initial brief and my reply brief, just as we stood below by the arguments we made in our response to the motion to dismiss and the arguments that we made in a motion for rehearing, just in case, after the fact, maybe the trial court just entered it like a little tunnel there, and just to remind them again of the fact that we filed a response to the motion to dismiss, we raised those same arguments again in our rehearing.
Now, why did it take 2 years to file the motion to amend?
So we talk about that a lot if you look at the motion, the actual motion to amend that was filed in the trial court. Gene Stevenson, who's the husband of the appellee, passed away. I think it was about a month after the order granting the original motion to dismiss. And then it also went on a loss mitigation hold, and this is all in the motion to amend itself. And you also note that the trial court said in the order granting the motion to amend, that's at, I believe it's 209 record site, the end of the preamble, and the trial court said that plaintiff has shown good cause for the delay.
And apparently there was no objection. I was just curious as to, what happened.
Right, so that was the general course of proceedings. I'm relying on the motion to amend there. That's what the motion to amend says. I don't have a transcript of the hearing on the amendment itself, but regardless, as we said in our brief, any delay works to Stevenson's benefit. That's a velo from the 4th DCA in mortgage foreclosure proceedings. If you're going to have a delay, they haven't paid for many, many years, I believe. Default date was August 1st, 2011, so this has just given them even more time in the property.
Great country, isn't it?
I'm sorry?
It's a great country, isn't it?
So, a couple of things. The court was, and this seems to be the error, and also some of the arguments that the appellee raises in their answer brief, was focused on ownership, which is what an assignment normally conveys, is ownership of the note and mortgage. So if you're going to be proceeding as the owner of the loan instead of the holder. But as Your Honor, Judge Cohen noted in the beginning, we were proceeding on a blank endorsed note as the holder. So, and we addressed this in our response to the motion to dismiss, we addressed this in our motion for rehearing. Any and all arguments regarding ownership of the loan are and remain irrelevant. The only question is whether we held it. We did. If they have an issue with that, they can take it up at MSJ, motion for summary judgment. They could take it up at trial. There are several avenues they can fight against it. They could request discovery. But right now, again, we're just at the pleading stage. Our job is just to state a cause of action.
Are you aware of any case law that would support the position taken by the trial court that this was an appropriate motion to dismiss ruling as far as the standing issue?
So Stevenson cites Wildflower from this court. Wildflower says that ordinarily a motion to dismiss cannot raise affirmative defenses like lack of standing here. In some cases, statute of limitations, if there's an issue on the face of the complaint, then you can, in those exceptional circumstances, and that's Fariello also from this court, raise these affirmative defenses in a motion to dismiss. But that's not what we have here. We don't have an exceptional case. This is a normal case. The fact that an assignment is attached to a complaint, at worst, it would be saying that we're alleging both holder and owner. In neither case, so pleading an alternative, that would be in worst case scenario, in which case maybe they file a motion for a more definite statement, but it certainly does not contravene, repudiate, or contradict our allegation that we're proceeding as the holder. So in this particular circumstance, I do not believe Wildflower is appropriate because there is no error on the face of the complaint. The complaint, proceeding as the holder of the blank endorsed note, which is attached to the complaint.
And your contention is that for any of these arguments, the judge looked outside the four corners of the document itself?
So maybe not for any of them. I mean, there were some arguments over, so you're looking at both the plaintiff's name in the complaint. So in that sense, they're looking at the plaintiff's name in the complaint. But then when you turn to the 2012 assignment, the original assignment, that was attached only to the initial complaint. We attached a corrective assignment to try to mollify the judge to the amended complaint. But the 2012 assignment was not attached to the amended complaint. We raised that the trial court cannot go beyond the four corners of the
You're saying
complaint.
the judge could not be mollified.
No, the judge could not be mollified.
Can the trial court look at the original complaint and compare it to the amended complaint?
No, Your Honor. They are restricted to the four corners of the complaint. They could do that at a later time, at a motion for summary judgment, perhaps. I mean, even then, they'd have to tender, I guess, the original complaint as evidence, because on a motion to dismiss, it's only does the operative pleading, and it relates back, the operative pleading relates back to the inception of the case, does the operative pleading state a cause of action? So they're confined to the four corners of that amended complaint. And the judge at the hearing focused, nevertheless, on that 2012 assignment, the one that was not attached to the amended complaint. So that was an additional error. I would just, again, repeat, identity of the trust was irrelevant. I mean, even if the 2012 assignment of mortgage had been attached to the amended complaint, it doesn't matter if there's a scrivener's error in the name of the trust. At all times, we were proceeding as Wells Fargo Bank N.A. as trustee. Under Ginsburg, under Rule 1.210, subsection A, Florida Rules of Civil Procedure, that's all we're required to do. Every action may be prosecuted in the name of a real party in interest, but a trustee of an express trust, I'm reading from the rule, may sue in that person's own name without joining the party for whose benefit the action is brought, i.e. the trust. It's irrelevant what the name of the trust is.
Okay. All right, thank you.
Thank you, Your Honor. If the score has no further questions, I will save our remaining time for rebuttal.
May it please the court. My name is Nick Shanine, and I represent the Appellee, Grace Stevenson. This case involves a definite question regarding lead me not into error. If this court is going to protect trial judges when they are hearing arguments that are completely in opposite of what this court will later hear.
We've read their motion for rehearing.
That is correct, Your Honor. But what happened here is the judge asked a very specific question. And, this court's noted this.
Now, you're trying to tell us that it's not preserved, okay? And they filed a motion for rehearing that set forth what they're arguing on appeal. Why isn't that preserved?
The answer is because it may be preserved except for the fact that it has become waived or invited error. That when this company waits 3 years from when it files its complaint, given only 60 days to amend, it waits 2 years, works out a stipulation with the other side. I'm going to answer your question.
Right.
Works out the
Well, I mean,
stipulation.
you all agreed to it, and I'm sure your client's very upset that it's taken so long to get this foreclosure completed.
As Your Honor notes, it is a great country, but one of the reasons it's a great country is the defendant has rights, and the defendant has due process rights. And one of those rights is that if you're going to get sued, let's get sued by somebody who actually exists and has.
Now you're mixing apples and oranges at this point. Mr.
Counsel,
Shanane.
they filed a motion.
Sure.
Your client filed a motion. The other side responded in written form, raising these arguments. Then they get in and they find a trial court judge who is focused on one particular argument and has very specific questions about it, and has indicated that she has reviewed all of the papers, all of the motions. There's no indication they've waived the argument. She spends time asking questions about a very specific thing. She ends the hearing. She makes a ruling. They bring up those same issues again in rehearing. What else should they have done to preserve it, given that they argued it both before the hearing and after, and here?
Your Honor, at the first oral argument we heard, Judge Cohen asked the counsel, why shouldn't you be bound by the argument your counsel makes and that's a telling question, that when argument takes a position at a hearing and tells the judge an answer to a question and doesn't try to confine it, well, in that one particular issue, Judge, instead, this was the argument. It's really important. The question...
You ever had an oral argument, Mr. Shanane, where you didn't get a chance to argue what you wanted to?
I may be familiar with that feeling. That is correct. That said, this answer, when the judge asks him, if the wrong party sued in the beginning, you can't have the wrong party sue, then do an assignment after the fact and try and cure it when the party who initially sued was incorrect. That's the question from the judge. And the answer of the counsel is, that is correct, Your Honor. He tells the judge, what you just told me is in fact the law. And then he takes a new tact. He says, and the answer I would have for you is that this was not a simple assignment of mortgage, which was created in order to provide standing upon the plaintiff. It was a corrective assignment of mortgage. And that's from whence the rest of the hearing goes in trying to weed out what's the difference between a simple assignment and a corrective assignment, when of course the case law has no such distinction. But the critical part isn't even his side wanderings through a desert he created. It's his statement to the judge, that is correct, that what the judge has verbalized.
But as a conceptual matter, that's right. Yeah, that the answer to that was perhaps, as far as it went, it was right. But you had a situation here where there's a trust. They've got the note. Okay, they're the holder of the note, and they have a blank endorsement.
Sure.
And at that point, that's enough for a cause of action, and the cases on that are legion. At that point, this case, that motion to dismiss should have been denied, and if you want to raise it as an affirmative defense, you raise it as an affirmative defense. But they've got a copy of the note, and they have a blank endorsement.
And that would have been a fine response of this counsel. He'd made no such response.
And I could have billed $500 an hour for that.
and earned every penny, and I would testify to that.
If we get past the argument that it wasn't preserved and find the argument was preserved, is there still an argument that the trial court should be affirmed?
Well, again, once it's invited error, that is the answer to that question. But the reality is that the 2007 case of Ginsburg, if that case is followed, it would essentially dictate that it doesn't matter what you call yourself. You can call yourself refrigerator and sue, and yet somehow that's okay because you've got this blank endorsed note that you're holding, and you've alleged that in your complaint. I believe that Ginsburg takes that too far. I think the rules of pleading need to be the rules of pleading, that you can't claim to be a refrigerator when you're not. And I would go back to your question, Judge Roberson, that you asked, and whether or not these were two separate entities. And while I agree with counsel's response that the record isn't clear, I think what is clear is that these two titles, it wasn't simply that, oops, we mistakenly put one word for another word, and by the way, there was never a motion to correct Scrivener's error or some such, that instead the wording of the two were sufficiently different, even through the end where the one calls itself a mortgage pass-through certificates, comma, serving 2007-NCW, and the other does not, to make it clear that they claimed to be an entity that existed, it appears from looking at those two documents, when they weren't. And so I would answer that question this. It should not be the law that you can call yourself refrigerator
Well, you know, but
when
you're
you're
on
not.
motion to dismiss.
Sure.
Okay, we're not here on summary judgment. We're here on motion to dismiss.
Sure.
And the question is, does that complaint set forth a cause of action?
And the answer is that under the rubric of Ginsburg, yes. Under cases that had preceded it and the simple rules of pleading, the answer should be no. And so whether this court wants to extend Ginsburg to these facts, I would advocate that that would not be something that the pleaders of the world need, this easy out, that they can use any name they can think of or come up with, that it is appropriate for a motion to dismiss. that once you get to that motion to dismiss, normally it would be to amend with leave, but here, because of the great and inordinate time taken to comply with a 60-day rule, a 60-day order, and the arguments that had been presented by the counsel, the judge was left where the judge was left. And I believe that this court would be providing a both legal and properly equitable resolution to this by allowing the judge who had been invited to this specific error to have her order affirmed. And by the way, when I say her order, this was actually the accumulation of two separate judges who had ruled, both of them uniformly dismissing the complaint, alleging that Refrigerator was the proper plaintiff.
Well, all right, there you have it. Two people said that, so I guess they couldn't be wrong, could they?
Well, two is not a large enough sample size to meet the dentine factor, but it is certainly enough to suggest to us that these trial court judges were doing their job, and this court should, for the reasons stated, affirm.
Okay, all right, thank you, Mr.
Thank
Shannon.
you.
Always enjoy it.
May it please the court, if this court has any further questions on this matter?
All right, thank you.
Thank you, Your Honor.
All right,